What is a OWI? Operating while intoxicated. The key word is intoxicated. This is not a OWI class, but OWI is a problem, and we are involved in the serving of alcohol and have a responsibility to the public to help keep our roads safe. It all starts with the implied consent law. The implied consent law in Wisconsin is this. Wisconsin's implied consent law specifies that any person who operates a vehicle within the state is deemed to have consented to a chemical test of blood, breath, or urine. After being placed under arrest for an OWI, a driver is required to submit to the officer's requested test. If the driver refuses to comply, the driver will face the following penalties, and the officer can still apply for a warrant to forcibly obtain a blood sample. Consequences of refusal. License suspension. Refusal of a lawfully requested chemical test is not a criminal offense, but will result in license revocation. A first test refusal will result in a 1-year driver's license revocation. A second refusal will result in a 2-year revocation, and a third refusal will result in a 3-year revocation. All refusal occurrences within the last 10 years are considered in calculating the prior offense. Any driver who refuses testing while transporting a passenger under the age of 16 will have his or her revocation period doubled. Restricted license. As with an OWI suspension, drivers with a revoked license for test refusal are eligible for a hardship license. This temporary restricted license permits driving only for certain purposes like work, school, and treatment, and requires the use of an ignition interlock device. Before being eligible for hardship license, applicants must complete 30 days of suspension for a first offense, 90 days suspension for a second offense, and 120 days of the suspension for a third offense. Refusing the test does not get you out of an OWI. Evidentiary users. While chemical test results are important in proving an OWI, the fact that a driver refused to submit to testing can actually be used against him or her at trial. Refusal doesn't exactly prove intoxication, but prosecutors often argue a refusal is indicative that the person was trying to hide intoxication. In Wisconsin, drinking and driving is known as operating a vehicle while intoxicated, or OWI. OWI laws prohibit operating any vehicle, car, snowmobile, boat, etc., while drunk, which is usually determined by blood alcohol level. Blood alcohol concentration, BAC limits. The BAC limit in Wisconsin, at which no other evidence is required to show the driver was intoxicated for an OWI conviction, is 0.08%. That's the per se BAC limit. This is called the prohibited alcohol concentration, PAC, in Wisconsin. If you get an OWI, you'll most likely get a second citation for a PAC, prohibited alcohol concentration. You can still get an OWI with a BAC under 0.08 BAC if the prosecutor can show how poorly you did in the field sobriety test, such as the HGN test, walk the line heel to toe test, or stand on a one-leg test. Also, for anyone under the 21, the legal drinking age in Wisconsin, there's a zero tolerance law. The BAC limit for an underage driver is 0.02%. Drinking and driving at all while underage can get you an OWI even if you feel sober. You can also be charged with the OWI even if you blow a .0000. The intoxicant doesn't have to be alcohol. It can be any intoxicant, such as marijuana or prescription painkillers, or a combination of drugs and alcohol. If convicted of BUI, boating under the influence, in Wisconsin for the first time, here's some quick facts for you to think about. Like OWI, those who operate a boat in the state are not allowed to have a blood alcohol content level or BAC of 0.08 or higher. Penalties for BUI in Wisconsin can include fines, impounded boats, and jail time. Anyone found to be operating a boat or other watercraft is deemed to have given consent to an alcohol or drug test by authorities. Fines of $150 to $300 can be issued to those who are operating a boat under the influence or violating the refusal law. For second offenses that occur within 5 years of the first can carry fines ranging from $300 to $1,000 with possible jail time. Third offenses carry even larger fines and longer jail sentences. BUI offenses do not affect boating privileges, but can include court-ordered alcohol and other drug assessments that require participants to provide a certificate of satisfactory completion after taking a boating safety course. If the person already has a valid certificate at the time of arrest, they need to repeat the process to acquire a new one, or the current one will be revoked.